afternoon, everybody. Thank you for joining us again today. As you are aware, the South African Bar Association hosts a speaker on a bi-weekly basis to deal with a legal topic that interests both parties locally and internationally, with training and development, which ties in perfectly with our core values as an organization. Before we commence, just some housekeeping. An appeal to all participants to please ensure that your microphones are muted and your videos are switched off during the address. Should you have a question, feel free to type it in the chat box, which we will address at a later stage during our Q&A segment after the presentation. Without further ado, I'm delighted to introduce our speaker to you today, and that is Advocate Les Morison SC, who will be addressing us on pleadings. A quick bio on Advocate Les Morison SC. He is a graduate of the University of Natal. He did articles at Harvey Nozzle and Company and served 2 years as a professional assistant at Raymond Tucker. He started at the bar in 1990 and graduated as one of the top 4 in the bar exam. He took Silk in 2009. He is an admitted solicitor, non-practicing of England and Wales. He has a qualification in teaching with technology obtained through UCT in 2022. He has presented a lesson on pleadings to the associates at Weber Wenzel for the past 10 years. He is also an author of the book Saturdays Are for Poetry, and he also wrote and staged a play at the Santon Theatre on the Square. I believe the play was premised on a conversation, or rather an anecdote told to him by George Bezos SC, the late George Bezos SC, about the award of the Nobel Prize to Nelson Mandela and F.W. de Klerk in Oslo, Norway. The play was nominated as the best play of 2011 for an Aledi Award. He is also married to Judge Ingrid Opperman, and they have 2 children. Ladies and gentlemen, thanks again. And here to take over for me is Advocate Les Morison SC, who will be addressing us on pleadings.
Thanks, Alebacheng. Thank you very much. I believe that my wife has actually addressed your organization as well, and she was warmly welcomed and she had a terrific time. So thank you for that too. My topic for this afternoon is pleadings. And as you will have heard, I've been working in teaching with technology as an interest of mine, trying to broaden the accessibility of pleading teaching materials. So what I've arranged to do this afternoon is to share with you one of the little videos that I made on pleadings, on the anatomy of a particulars of claim, which lays the foundation for the next talk, which I've also pre-recorded. And then once that's been presented, I will take questions under Alebacheng's chairmanship or chairwomanship. So if I can then start sharing my screen and playing the video that I have for you, and we can watch that with some amusement, hopefully. This is how it goes. Right, it's quite short and it's quite simple, but it's the foundation of the metaphor we will use for the rest of the afternoon. Let's just stop that. Great. Good afternoon. My name is Les Morison, and I'm here to talk to you about pleadings. Let's start by taking pleadings and turning them upside down. Let's start with the prayers. That's where the plaintiff prays that the court orders the defendant to give back the plaintiff's property or to pay the plaintiff so much money and to pay interest and costs. Prayers are that part of the pleading that's useful to focus on because they appear both in action proceedings, trials, and in motion proceedings, applications. In actions, of course, the particulars of claim end with the prayers, and in motion proceedings, the prayers are in the notice of motion. The prayers are what pleadings are designed to culminate in. They are the pinnacle of the pyramid that is built to give the court the conviction that it can send the sheriff off to go and make the defendant do what the plaintiff wants the court to order the defendant to do. The court needs to be sure that when it sends off the sheriff to execute the prayers that have been asked for, it is doing the legally and factually correct thing. We'll come back to that phrase, legally and factually. The court also needs to know that if it is going to refuse what is prayed for, then it must do so on just and fair grounds. The plaintiff in the action scenario, or the applicant in the motion scenario, let's just call them plaintiff for now, has put a lot of effort, a lot of money into bringing their case to court. And the defendant in the action scenario, or the respondent in the motion scenario, let's just call them the defendant, has put up their defense at a substantial cost in money and stress. And at the end of their plea, or at the end of the answering affidavit, the defendant prays that the plaintiff's claim be dismissed with costs. That's also, of course, a prayer. So the court is confronted with a prayer for the plaintiff's relief or a prayer for the defendant's relief. And even in exceptions, there has to be a prayer at the end of the exception, upholding the exception, giving the other side an opportunity to amend, and so on. So prayers are a very good place to start looking at pleadings. And whichever way the court is going to go on the prayers, it needs a solid scaffolding, a solid skeleton that is justifiable on legal principle and supported by authority before it puts out a judgment based on those bones. Both the plaintiff's case and the defendant's case need a good legal scaffold, a sound legal foundation. But of course, bones are not enough to get you a judgment. Yes, there must be a viable skeleton, but skeletons don't win competitions. They need muscles, hearts, digestive systems, cooling systems. They need the flesh of a living human being. And that flesh in our metaphor is, of course, the evidence, the facts that we add to the legal bones of the pleading. Inside the body of the winning case, the bones have to be properly constructed and they have to culminate in a prayer that follows legally, logically, and on a sound factual foundation from what is pleaded and the evidence that ultimately is led. Picture it this way. The bones of the pleading are set out as you would in a particulars of claim. The plaintiff is, the defendant is, the cause of action is, say, a contract. The contract was concluded on such a day by the following representatives of the parties, the plaintiff and the defendant. The contract contained the following terms. One or more of those terms was that the defendant had to do certain things. The defendant failed to do that. That failure was a breach of the term of the contract. The breach resulted in the plaintiff issuing a demand to the defendant to comply with the obligation under the contract. The defendant failed to comply with the demand. The plaintiff decided to enforce the contract to seek specific performance. Alternatively, if the defendant persists in refusing to render performance, then the plaintiff will cancel. And then the prayers. Plaintiff prays for specific performance of the contract. The plaintiff requires the defendant to deliver the plaintiff's property. And if the property is not delivered, then in the alternative, the plaintiff cancels and requires the defendant to pay the value of the property lost plus damages, plus interest, plus costs. If that was in the particulars of claim, it would probably be non-excipiable. No exception could be delivered to a set of particulars of claim that satisfied the essential requirements for a contractual cause of action. But to actually succeed with that cause of action, as set out in the particulars of claim, to get what your client prays for, you would need to go to trial and add the evidence. Courts can't work off the assumption of factual correctness other than at the exception stage. Yes, we ask, in the exception, will the skeleton hold? If yes, then that exception is dismissed and the flesh is allowed to be added onto the bones. The case could go to trial. The pleading is sufficient as a foundation for the evidence to be led. On this example we've just used, the contract itself would be presented in evidence. If written, the document would be put up. If oral, the person who concluded the oral contract on behalf of the plaintiff would testify to its conclusion, its terms, and the actions of the parties towards the performance of the contract. If written, he or she would identify the signatures of the parties to the contract. The witness would explain how the defendant failed to perform, explain to the court how the demand was sent to the defendant, how the defendant still refused to perform, how the demand was delivered to the defendant's registered office. That would all have to be produced by the testimony of the witnesses in the plaintiff's case, saying the defendant still hasn't done what they were obliged by the contract to do. And then, of course, there would be cross-examination of the plaintiff's witnesses by the defendant's counsel. The evidence would be tested. The court would decide whether not only are there good legal bones, not only has enough flesh been added to the bone, but is the flesh that has been added to the bone strong enough after cross-examination to sustain a viable case for the plaintiff? If the flesh fails, the fact that the bones aren't there doesn't get the plaintiff over the finishing line. I beg your pardon. If the flesh fails, the fact that the bones are there doesn't get the plaintiff over the finishing line. The evidence is insufficient to discharge the onus, for it is the party who has to add the flesh who is the party who we say bears the onus of adducing evidence. Let's look at a motion now. A motion does the same thing. There is a set of particulars of claim hidden in the text of the founding affidavit. Each averment that makes out a cause of action in the particulars of claim must also be present in the founding affidavit in a motion, which supports the notice of motion, where we find, of course, the prayers. In the founding affidavit, the flesh is not that of the witnesses giving oral evidence from the witness box as in a trial. Rather, the evidence is wrapped around the bones in text of the affidavit and in the annexes, the documents attached to the founding affidavit about which the deponent to the affidavit speaks in the affidavit. In a claim of ownership, a reivindicatio of fixed property, the witness will say, attached to my affidavit is the title deed of the fixed property. The name of the owner of the fixed property on the title deed is the name of the applicant, and so on. You can't just add documents to the founding affidavit without actually explaining in your affidavit why you are attaching them, which part of them you rely on, and what the document means for your case. Under oath in the founding affidavit, just like in a witness box at a trial, the applicant's witness says, I concluded this contract. It is attached as Annexure A. I refer to paragraphs 12 and 13 of the contract. These paragraphs oblige the defendant to deliver the thing to me by the 25th of April, 2023. He did not do so. I phoned him. He didn't answer my calls. I sent him an email. This is his email address. There is a copy of my email attached as Annexure B. And so we attach the annex, the documentary proof just as in a trial. And then that is the basis on which the court must be persuaded and convinced that a proper legal cause has been made out and that proper evidence, factual substantiation for the legal cause exists to sustain the granting of an order against the defendant. Coming back to the trial or action proceedings, what if the defendant in their plea to the plaintiff's particulars of claim simply denies the averments made by the plaintiff? For example, where the plaintiff has pleaded, I concluded a contract with the defendant, and the defendant simply pleads in their plea, I deny that the contract was concluded. What's going to happen in the trial with that denial? Here is a likely scenario which makes it clear that pleading bare denials is dangerous, if not unethical. The scenario is that a defendant can come to court having pleaded a bare denial and say, when they get into the witness box, well, I deny that that contract was concluded because it isn't my signature, it was a forgery, and the agent who forged my signature wasn't authorized to sign it on my behalf. To which the court, hearing the trial, might say, following an objection from the plaintiff's counsel, you can't go into that additional detail because you didn't plead that defense. You didn't plead, for example, that your agent didn't have authority. You didn't plead, for example, that the signature was a forgery. You just denied that the contract was concluded. And because the plaintiff has said in their testimony that they saw you sign it in front of them, and they called the witnesses who signed it and who witnessed your signing it, you were not, Mr. Defendant, permitted to introduce a whole lot of new evidence to support your denial because your denial was so boldly pleaded. None of these material facts were pleaded by you, and you are confined in our system of civil litigation to your pleaded case. And if your case is simply that you deny that you concluded the contract, you can't go beyond that simple denial in your evidence. And that is how pleadings work, to support the claim or the defense that is advanced. Pleadings give the other side notice of what is going to be brought along to trial in the way of evidence. And that is the whole function of pleadings in actions. Pleadings describe the boxing ring within which the fighters will conduct the fight, but they exclude fighting outside the ring. In motions, of course, the pleadings are harder to separate from the evidence because wrapped up in the evidence are the pleadings. So when the founding affidavit arrives, no more can be added in the way of pleading or even evidence other than the replying affidavit, which follows the answering affidavit from the respondent, and I'll come to the replying affidavit. But no more can also be added in the way of evidence other than in the replying affidavit, which I now come to. What is the function of a replying affidavit in motions? It is the same as a replication in action proceedings. It is to confess and avoid. We know that the three ways that one can plead are to admit, deny, or confess and avoid. A confession and avoidance is typically set out in a replication in an action where one has, for example, a plea of prescription raised against you, where the defendant says, you know, Madam Plaintiff, that this claim existed more than 3 years before you instituted the action. The 3 years expired. You only instituted your action after the expiry of the 3 years. Therefore, your claim is prescribed. The Prescription Act bars you from pursuing this claim after 3 years, and I want your claim dismissed with costs. To deal with that, the plaintiff has to replicate. The plaintiff has to say in that situation something like, yes, I confess, more than 3 years have expired after the claim arose, before I instituted the action. That's my confession. But here is my avoidance. You, Mr. Defendant, concealed from me the fact that this claim existed, and I only found out about it a year before I instituted action. So prescription should only start to run from the time that I knew about the claim, or could reasonably have found out about it. And where you, the defendant, kept me in the dark about the claim, I shouldn't be barred by prescription. That's a classic confession and avoidance. And that's the sort of thing that is legitimate and in fact necessary in a replication to plead in an action. In a replying affidavit, you would do the same sort of thing. You would set out the facts that neutralize the effect of the defense raised in the answering affidavit, if you had such facts available. So, for example, the respondent in their answering affidavit could say in a claim for their eviction brought against them by a landlord on the basis that the rent was paid late in breach of the lease. I paid late every month for 6 months. I know I was supposed to pay on the 1st of the month, but I paid you every month on the 7th because, being an advocate, that's when I get paid by my attorneys. And you were fine with that in January. You were fine with that late payment in February. You were fine with the late payment in March, April, May, and June. Now, suddenly, here we are in July, and you, Mr. Landlord, are saying I breached by paying July's rent on the 7th. Suddenly, I should have paid on the 1st, and now you're trying to evict me because I didn't pay by the 1st, as the lease says I should. Well, you are stopped, says the tenant. In fairness, you, Mr. Landlord, held out and represented to me that you were prepared to accept the rental on the 7th of every month. And your representation, upon which I reasonably relied, after I had paid late on 6 separate occasions, entitles me to rely on it to invoke the doctrine of estoppel, the equitable doctrine that says you can't hold out one thing and do something different to the prejudice of the other to whom you held out things in that way. And that is the end of the plaintiff's case for eviction, because the plaintiff should be stopped from asserting that payment had to be made on the 1st because of the representation upon which I reasonably relied to my prejudice. Estoppel, like prescription, is another classic example of a confession and an avoidance which can be raised in a replication or a replying affidavit. So when people complain about replying affidavits containing new matter, what they really mean is the replying affidavit contains a new cause of action. You can't put a new cause of action into a replying affidavit. Why? Because there's no opportunity to answer it. You cannot make out a new cause of action in the replication, in an action. That's also impermissible. The cause of action has to be in the founding document, whether it's a particulars of claim or a founding affidavit. But there can be new matter in the replying affidavit if it is a proper response to the answering affidavit, which, as I've indicated, a replication of estoppel would be, and a replication to prescription would also be a proper form of plea to include in a replying affidavit. So just like we say that prayers are common to actions and motions, so we see causes of action are common to motions and actions. And we see that admissions, denials, and confessions and avoidance are common to actions, as is the necessity to produce cogent evidence before you can get a result in your favor. Exactly the same task is being performed. It is just that in actions, the court has to work out what the facts are from the evidence, whereas in a motion, the court should not have to work out what the facts are. Both sides should be agreed on the facts. A good example is a dispute over the interpretation of a contract where both parties accept that the contract is the document attached to the founding affidavit. But the one side says, for example, that days in the contract means court days, and the other side says days in the contract means calendar days. Was the rent late? Yes or no? Depends on what you interpret the term days to be. That is a pure dispute of interpretation, not of fact. Motions are designed to decide cases like that, where there is no dispute of fact. Cases of interpretation of law or documents. Of course, with the new regime on admissible evidence on interpretation, it may be wise to ask for questions of interpretation that are particularly thorny to go to oral evidence so that the context can be more fully ventilated. I hope that you are seeing that courts in both motions and actions depend very heavily on pleadings to perform that very important function of filtering out unworthy claims to prevent injustices and the unjustifiable use of civil force via the sheriff of the court to do things that haven't been properly proved in court on a sound legal foundation. And let us remember that the sheriff can bring in the police, the red ants, and use reasonable force where necessary. So this is an important safeguard. With that background, let's look at the question of relevance. What is relevance? In a trial, you'll often find your opponent standing up and saying, that's not relevant. Well, relevance is something that helps the court decide the issues in the case. So relevance and issues are very closely related concepts. And the question is, does it help the court decide an issue or not? How do we work out what the issues are? We look at the pleadings. We take the particulars of claim, we take the plea, we compare them. And where the particulars of claim makes a particular allegation and the plea denies it, you put a red cross next to the paragraph in the particulars of claim, because that's been denied. Where the plea admits something, you take a green pen, you tick it in the particulars of claim, where it's been admitted. And where there's been a confession and avoidance pleaded in the plea, you make a tick cross on the particulars of claim. Then you look at your ticks and crosses and your tick crosses and the issues of those items, those paragraphs in the particulars of claim, which have a cross or a tick cross against them. Your job in the trial as the advocate is to adduce the evidence that has those issues decided in your client's favor. So if a piece of evidence will help the court decide an issue, then it is relevant. If it won't help the court, then it is irrelevant. Relevant evidence is admissible. Irrelevant evidence is not. Let's take an example. The plaintiff says in a medical negligence trial that the patient suffered a cardiac arrest whilst under the hands of a doctor because the doctor administered too much of a particular drug. Let's say the doctor was a plastic surgeon performing a nose job, and the plaintiff says that you, Mr. Defendant Doctor, used too much cocaine in the nose of the patient, which caused the patient to have a cardiac arrest on the operating table. You may be surprised to know that the use of cocaine is standard practice in nose operations because it stops bleeding very effectively. But cocaine is also a powerful heart poison. The defendant doctor then pleads that the dose and concentration of cocaine used in the operation was within normal clinical range, and therefore it was not negligent to use it in that way. In the evidence for the plaintiff leads a witness to say that it was the combination of the cocaine and the anesthetic gases which caused the cardiac arrest. The defendant's doctor's counsel stands up and says, the evidence of the combined effect of cocaine and halothane is inadmissible. It has not been pleaded. What was pleaded was cocaine alone in too high a dose and at too high a concentration. That's what caused the cardiac arrest according to the plaintiff's pleadings. Now we are hearing evidence that it was not the cocaine alone, but the combination of chemicals. And that is not the case that we were brought to court to meet. My witnesses have not prepared on that, and it is inadmissible because it is irrelevant to the pleaded issues. The pleaded issue is, was it cocaine, yes or no? Perhaps you might now understand what Harms J.A. meant when he said that cases are won or lost on the pleadings. They are the skeleton. Without the bones in the right place, the legally recognized and supported place, the flesh can never be successfully attached, and the case may look to the judge more like a Frankenstein than a Frankenfurter. Get your pleadings right and you have a winning case. Get them wrong and you're gone. How to do that? There is a book. It's called Amler's Precedents of Pleadings. It is available online or in hard copy from LexisNexis or the Bar Library. It has a chapter on just about every cause of action in South African law and many defenses. For example, the classic defenses to defamation actions of truth and public benefit, and so on. It is a very useful book. It needs to be looked at again and again when analyzing an opponent's pleadings and when drawing your own. Then, when you've drawn your pleadings and you think it ties in with Amler, take the pleading to a colleague to read through. They will see things that you may have been blind to. They may ask some hard questions. Go away and think about how you might answer them if a judge puts them to you. Change your pleadings if needs be. Think about the trial, the motion. Is the evidence actually available to support what you plead? If not, get it from your attorney, and if they can't get it, don't plead it, unless you have a strong belief that it will be forthcoming from the other side in discovery. And if it does not come out in discovery and you don't have the evidence to support your pleaded case, you must either amend to fit the evidence you do have, settle the case or throw in the towel before presenting a hopeless case, because presenting hopeless cases is unethical, because it takes up valuable court time and wastes your clients and the other side's money and time, and that we do not have a lot of. Happy pleading. Okay, there we go. Those are the two videos for the afternoon. I hope they were useful. Arabacheng, are you going to lead us into question time or discussion time?
Thank you so much for that. There is construction next door. You can't hear me properly. We don't seem to have any questions in the chat box. Please, if you have a question, feel free to raise your hand or just type in the chat box and I will read it out loud to everybody.
And the other thing we got
my camera off because my network quality is a bit poor at the moment. I hope that's okay, but I'll have my mic on. Thanks. I don't think we have questions today.
No, that's fine. The other thing we can do is I can ask, and I'd appreciate feedback on this, is was any of that useful? Did people find it was too lowbrow, too highbrow, too long, too short? Was it in any way beneficial? Because I'm still creating these videos for what I would have thought would have been useful when I was new at the bar. They're the product of a long time at the bar, but I may be wrong in that, and I'd appreciate somebody coming back on that.
Okay, there is a question. I see text box. She asked if we could have the name of the recommended book said again. I believe it was Amla's.
Yeah, Amla's Precedence of Pleadings.
Hope you got that, Nabile. And I see that Advocate Romeo tried to jump on. Perhaps he has a question or a contributory statement. Let me just give him a moment. Romeo? Advocate Tambeleni, are you there?
Yeah. Okay. Yes. Good afternoon.
Hello, Romeo.
Thank you very much. No, as a person who's also teaching motion code, I think your information was very invaluable. The way you have structured it and the way you have set it up, I really like it, and I think this was, given the short time that you were given within an hour, there's little that you can actually do. So, no, thank you very much for that. And I think, if we need a further engagement with you, maybe if it's about a 2-hour presentation, I'm definitely feeling that you're going to actually add more. But I'm sure that we are restricted in terms of time, in terms of what you can actually offer. So you taught me pupillage, so I don't have any complaints whatsoever. So thank you very much for that presentation, Les, and taking your time to do a presentation for us this afternoon. It means a lot to us. Thank you very much.
It's a pleasure. Thank you. I should mention that I tried to do a TED talk on this a while back or something similar, and I read a book called How to Do a TED Talk, and I was surprised that the maximum time for a TED talk is 18 minutes. And the reason is that people only concentrate for about 18 minutes. So that last lecture that I did or that last talk that I did in that video was 25 minutes. So it was 7 minutes over the TED talk limit. And of course, the animated video of the skeleton was just to prompt a little metaphor in your minds. It's hopefully a little more memorable, because it's easy to speak of the metaphor, but when you start exploring it, it becomes quite beneficial in giving clarity, I think.
Thank you for that, Les. I personally enjoyed the graphics. I'm a visual, creative thinker type of individual. I learn best by pictures and color. So with that being said, I don't know if it's possible for you to share that little doodle video that you had in the beginning with us. And I'm sure it will forever be worth a while to have it in our archives. Very simplistic, but also detailed. Thank you for that. Laura wrote in the text box, thank you for the session. It was indeed helpful. Hence, there are few or no questions. You covered everything nicely. I share the same sentiments. Thank you for that, Laura.
It's a great pleasure. I'm putting all of these up on YouTube, and I'll send you the link to the channel, and then you can work through them. There are a few that go a little further. One of the things that's been fascinating me of late is how two wrongs make a right. And in history, in the war in the Ukraine, you see the Russians complaining about Ukrainian history, and you see the Ukrainian people complaining about Russian history. And it seems as if human beings are capable of blaming one another infinitely if you give them enough time from which to draw a set of complaints. So one of my last videos that I've uploaded is one called When Two Wrongs Make a Right. And you'll have to forgive me for that one because it's not very legal, it's more philosophical. But I thought I should perhaps give you a little context to that if you do click on it. I'll send through the link shortly. I did also send through the text of that address, which I was reading into the camera last night to make sure that it wasn't too long. And I thought that'd be the easiest way to get it across with few interruptions and clarity. So if you require the text of that address, that is available. And I should point out that watching it now, I realize there's a logical flaw in it, in a sense that when I used the example of the landlord and tenant, I really used estoppel in the context of a plea and not in the context of a replication or a replying affidavit. But it's a good enough illustration of how estoppel works as a defense, and I wasn't too unhappy with how it came out, but it's not perfect in that respect. So thank you very much for all your attendances and for your kind words and for the honor of being able to address you. It's a great privilege, and I look forward to seeing you in court one day. Hopefully I'll come across some of your pleadings.
Thank you. Thank you so much, Council, and thank you for everyone who tuned in to our session. We'll see you again in time.
Maybe before Les leaves, maybe just one question, just as a question of interest, no less. Remember that in the past, you in the High Court, you could ask for better particulars, and then now that it has been outlawed, just for the benefit of peoples that are here, that when they are confronted with the particulars of claim, that they think that they've got those challenges, that they don't disclose the course of actions and all those kind of things that we have to deal with in terms of the role. What is the best way to actually approach them, no less?
Okay, so thank you for that question. It's important to address it in the two chapter headings. The one is a failure to disclose a cause of action, which would be a missing bone in our skeleton, and the other is vague and embarrassing. Of course, where it's vague and embarrassing, as you know, Romeo, the obligation is on the party receiving the vague and embarrassing pleading to deliver a notice requesting the party delivering the pleading to remove the cause of complaint and give them 10 days to resolve the fact that it's vague and embarrassing. But a vague and embarrassing exception, if it is delivered because the notice is not complied with, is always a complaint that goes to the root of the pleading. And if it can be cured by requesting further particulars for trial, then it's not appropriate to take an exception to that pleading. It's more appropriate to request the particulars for trial in due course. And that authority for that proposition is a case called Jowl versus Bramwell Jones, which says that if you're dealing with vague and embarrassing, the nature of the vague and embarrassing complaint must go to the cause of action as a whole, and if it can be cured with further particulars, the exception is not the appropriate procedure.
Okay. Thank you very much. That answer not the question. Maybe what you can just do less is to post the case law on the platform, so that at least those that are interested in checking that case law will be able to use it in future when they're confronted by them.
With pleasure. I'll see through a summary of what I've dealt with this afternoon with pleasure.
All right. Thank you very much. No less.
Thank you very much. I'll say goodbye.
Thank you.
All the best. Have a good afternoon. Bye.
Yes. Oh, there's a question.